Okay. We got everybody. If y'all can just, somebody just give me a thumbs up to make sure that y'all can hear me. Certainly don't want to be down the line and find out that you can't. All right, cool. Thanks, Chris Spoo. Chris Spoo, that's a new name. As I Google you, if this is your first time coming on the webinar, I'll give you a quick rundown of what we do. And so this is our, what month is it? July? No, way off. I'm gonna do this again. This is our May of 2023 webinar. If this is your first one joining, we kind of follow the same pattern. I usually have somebody join me. Today it's gonna be Chris Stokes, and we're trying to give you real, honest, actionable things that you can do to improve your, whatever the topic is, improve your depositions. We have a webinar on that. Improve your damages and how you're going to present them. We've got a webinar on that. At this point, I don't know how many webinars I've done, but since April of 2020, when I was doing about one a week during COVID, since then, I'm pretty sure we've done in excess of 50 webinars, all of them free. I'm not trying to sell you a mastermind group. I'm not trying to make you pay me for this advice. I do this because I have fun talking about this. And I do think that the results of everyone else around us and lawyers as a whole, if we are better lawyers, it bodes better for me. And I'm trying to be on your mind when you say, oh, I've got this case, I don't know what to do with it, or it's got this issue, it's got this positive, whatever it is. I hope I'm on your mind. At a minimum, give me a call. Let's talk about the case. I'll probably buy you lunch too. And I'm excited to say, for the first time in a very, very long time, and I'm going to send everybody an email after this, my firm is actively looking for cases. It's probably been, I don't know, 3 years since we have looked around the hallways and said, well, shit, let's go get some cases. We haven't had really the opportunity to do that because we've been really busy. So for the first time in what I would call like a whole case cycle, we are actively hunting for really good cases and to work with really good people. So this first quarter into the second quarter of the year has been pretty phenomenal, frankly. And we're looking for more cases that we can crank out and do a phenomenal job on. After this webinar, if this is your first time joining, after this webinar, I will send an email out with our 5 tips. So that way you have them and can reference them. And I'm also gonna give you a breakdown of what our year has been like so far, because we've had some really good successes, some that we've talked about on things like this, some we haven't, and I want to share with you guys. So without further ado, I am going to, if I can figure out how to do it, I'm going to bring Chris Stokes from my office into the mix. Chris tried this case with me. The case is Duncan versus MARTA. That's what we're going to talk about mainly today. Duncan versus MARTA. And woo, there's for a 3 or 4 day trial, whatever it is, there's a lot to talk about. And Stokes needs a ring light. Can we buy one of these on Amazon? It's been 3 years. Can you get a ring light?
I've got a lamp with just a general light bulb, LED.
I'm trying to tell people to send us cases and tell them how good how great we've been doing this year. And that's true. And then there's you sitting in the darkness in a weird corner with nothing on your wall. How long you worked here for?
I've got some stuff that I've been thinking about hanging for a couple of years.
Yeah. Yeah. Stokes and I have worked together, I think, for 5 years now. You told me that the other day and I was stunned.
Yeah.
And we've been in this office since January of 2020.
Yep.
So anyway, the case is MARTA versus Duncan. The easiest way for us to tell you about the case is just, thankfully, we can show you. Stokes, can you cue this up?
Yeah.
So our client is a Lyft/Uber driver. She's driving rideshare. She has her daughter in the car and they're just driving around one night doing some work. They get a call to pick up somebody near a MARTA depot. That's where the MARTA buses come back. And she gets there and she picks up a MARTA bus driver who is now off duty. He gets in the car, they pull out and they come to a stop sign. And they're sitting at the stop sign. And if we're good at this, then we're pretty much on cue. And Stokes is going to share his screen. And it's going to be amazing. There you go. So this is, as you can see from the screen, this is the side view camera. Stokes, just run it. We'll run it a bunch of times like we did at trial. This is the side view camera of the bus, and it's going to make a left turn right here. Don't blink, people. Don't blink. 3, 2, 1. We've got a couple views. I don't know how easy it is for us to, let's play this one again though. This is the best view. I mean, I can show you inside the bus shaking a little bit right here. One more. Yeah, there we go. You have the property damage photos?
Yeah.
So obviously, by the looks of it, not a tremendous impact. Not a tremendous impact. Here's what it looked like at the scene. By the way, you see that Morgan & Morgan billboard on that bus? See that Morgan & Morgan billboard on that bus? We still got this case. Come on. We still got, no. So this is, where's the decent one? That's a little closer. I think it's the third one. That's probably the best view that we have. So we go to the first one because that has the debris, right? It's been, yeah. So all that stuff on the ground is debris from the vehicle, from our car. Can you show the MARTA dent?
Yep.
So if y'all have ever had a MARTA case or a case with a ton of video, you know, it's very time consuming to sit here, but the great part obviously is you know everything that's happened. So one of the fun things, here we go. This is the side of the MARTA bus. And one of the fun things at trial was I asked the guy who took this photo, did you take this photo? And he goes, I don't know. And then I was able to show him a video of him taking this photo. So it makes your world a lot easier, and it narrows the world, obviously. Stokes, can you show a couple different clips? I want to talk to the first thing I want to, and I don't even know if this wasn't one of our 5, but I wanted to say it anyway. When you have a case, because Stokes and I have another one, a Kroger case with a ton of video. Alex and I have a Dave and Buster's case, Simon Mall case with a ton of video. What I think is really important in terms of your time is try your best to watch the video once and take timestamps as you go. And you can ship it out to somebody, you know, through an online service and ask them to kind of timestamp your video and give you a running idea of what happens. If it's short enough, you can do it through AI. But what we did was we cut a bunch of different views, and it was important in this case, I thought, to show the jury every single view that we possibly could. So here were all the views that we had. And if you haven't seen the MARTA camera system, you kind of double click on one of these and it opens up to be a single screen, which is how we got the last view we were showing you. So, you know, these are the views we have. And, you know, we sat here and I don't know how many times we've watched these videos now. Hundreds and hundreds of times. I can tell you in camera 2, I can tell you, you know, what his reaction is going to be and what's going to shake. The same with camera 5, with that big black thing on the right of camera 5. When there's impact, that's actually going to shake pretty significantly. So, you know, you do need to watch it. But if you have a huge amount of video, I implore you, timestamp the video as best you can, take notes, and then start cutting it. Throw out the stuff that doesn't matter and then focus on the stuff that does. So just a little side note. But obviously, this is the case. Not a huge impact. So how did our client get hurt? If you ask her, her answer would be, my foot was on the brake, the bus came, and it caused the front driver's side, kind of near my tie, near her tire, near her door, to buckle in, to come into the compartment. And she says there's a cup holder in her door, and that cup holder hit her foot. What do we say at trial in closing? So I believe that she believes that.
Yeah.
I believe she believes that. And I told the jury that. I was like, I believe she believes that. I don't think that's what happened, though. I think what happened is her foot slipped off the pedal and hit maybe the door, hit something, and it caused a foot injury. Now, I'm not going to give you the medical science here. I'll give you the quick rundown. Essentially, your heel bone and your ankle and your foot bone all merged together when we're little. But for actually a larger percentage of people than I ever would have thought, that doesn't happen. And she is one of those people where her bones essentially did not form in the back of her heel the best way they could have. And she could have very easily gone through life without anything. And what did Dr. Barber say? It was like most people, when he sees it, he doesn't even tell them.
Yeah, I mean, it shows up on an X-ray, but it's not even really a dormant condition, which I'm sure we'll talk about, but it's really just something that as you develop doesn't form the way that it's supposed to, and it may have some pain at some point, may have none at all.
Yeah. So there's, I think statistically, there's probably one person on here who at least one who has this formation of bones that don't essentially touch and support each other. Instead of three bones coming together, and I can't do three fingers, but instead of the bones coming together, the bones are not fully formed and fused together. And it's from childhood. I mean, it's from birth-ish. So she's going through life, has no idea. And then she has this injury, this impact, whatever word we want to call it. We were much more careful at trial not to run on calling it an impact, but this happens to her and now she's in pain. And she needs an arthroscopic surgery to repair the problem that's down there. That's all we really need for this scenario. Her bills were 130.
Yep, around there, 130, 140.
Yeah, and she hadn't treated since, was it 19 or 20? I don't think she had treated since 19, definitely since 20. So it was tough for us to, at least we thought we were gonna have a big problem showing a permanent injury and lifelong injury. Although we had the testimony from her treating surgeon. So how did MARTA defend the case? They did weird stuff. Cameron Hawkins is probably going to watch this and get angry that I'm talking about, saying he did weird stuff, but it was a weird defense. For all of discovery, they claim that they did not cause the crash, which is odd because we have the MARTA bus driver's report says, yeah, I caused the crash, my fault. And he says it on the video because in addition to the MARTA cameras, we also had police body cams. So he told the cop, yeah, my fault, my bad, I did it. Which I thought was the right thing for him to do. And then MARTA denies that they're responsible.
Yeah, I think the MARTA investigator actually showed up.
Yeah,
and thanked the cop for not issuing him a citation. And the cop goes, well, no, I'm still finding him at fault for the crash. I'm just not issuing him a citation for this. So it was very, very clear that everyone other than maybe the lawyers in the case or whoever started the litigation strategy knew that this was a clear liability case.
They should have known, and they did know, but they did this weird thing where they said, well, we admit it, but they didn't. I mean, they said out loud they admitted it, but they refused to do it. So we actually filed a motion for summary judgment. I like the idea of filing a motion for summary judgment in this scenario, because then you get to say the judge has already found. The judge has already found. It's already been decided that. So we did that. MARTA had a orthopedic expert. They then withdrew that expert before trial because that wasn't going to go very well for them. And when you come into trial in a case where you've disputed the obvious and then been forced to agree to it, you don't have any medical testimony and you have no expert witnesses of any kind because they've all been essentially eliminated. And then you come into court and you say an opening statement that the plaintiff is playing games and here to trick you for money, right? I think that was it.
Yeah.
So we started with a bang in this case, and it ended with MARTA in closing being more aggressive, even by telling the jury that their case got better. And in opening, they said, you should award a little bit of money. And in closing, they said, you shouldn't award any money. Jury awards $1.2 million. And we'll talk about the ask in the end, but Stokes actually handled jury selection. It was an interesting jury selection. It was a very short jury selection. We're going to be careful about what we say, right?
Yes.
But the facts are that Stokes was about 20-25 minutes into jury selection. The question that he asked of all the jurors was, who here has been involved in a motor vehicle crash, right? Or who's here been hurt in a motor vehicle?
Been injured, yeah, in a motor vehicle crash.
And what'd you get through? 4 of the people that had raised their hands?
Yeah, and we had a room full of people that raised their hands. I mean,
oh yeah,
And we needed to know that information because obviously if anybody's picked a jury in a personal injury case with a car crash, you want to know whether they've been in a crash, whether they were injured, what the property damage was, what the result, whether they went to go get some treatment, and whether they made a claim and what the result was. Those are the things you want to know because those are outside opinions that form their knowledge of the circumstances that they're about to have to decide a case under. And so
Yeah, the judge just says to him, "Are you going to ask?" Or he goes, "Are you going to ask every juror that?" And Stokes turns around and goes, "Yes, Your Honor." And then he goes, "No, no, no. Oh, no. Here's what he did. He said, 'You're not going to ask every juror that, right?'" And Stokes goes, "Well, actually, Judge, I'm planning." And he goes, "You're not going to ask every juror that."
Yeah. So, I mean, I think the takeaway from jury selection is one, and we could touch on this a little bit. You need to be prepared to try your case, even if you're number 2 on the calendar. We found out that we were officially trying the case, and we had prepared for it that morning because the defendant in the case number 1 ahead of us had a family medical emergency. And so the judge was like, "Okay, is case number 2 here?" And we were like, "Yep." And 10 minutes later, we were picking a jury. And so if we hadn't prepared the case, even though on the elevator up, we said to ourselves, there's absolutely no way we try a case today. We ended up doing it. And if we hadn't been prepared, we would have been in trouble.
Yeah, we were walking here, I'm betting how quick we'd be back at the office.
Yeah, exactly.
Yeah. So, and we little did we know the 3 cases, or the 3 cases that were called with the one in front of us was also a MARTA case, but different defense lawyers.
Right.
So MARTA was as unprepared as you can be in a case for that day of trial, and which is crazy because they were the defendant in the other case that was ahead of us as well.
Right. But so, as far as jury selection goes, we always try and frame our questions. You can't tell a story so much, but you can try through your questioning. You try and make your questions in an order that you elicit the most response out of people, broader questions than narrowing it down, asking questions which in different ways that may prompt people to give different answers. But the takeaway is that you need to know how the judge in your courtroom conducts jury selection. And we typically do that. This was an odd situation where we didn't know who the judge was going to be. It was in the Fulton County ORCA trial system, where they're trying to really get through a bunch of cases and they're bringing in senior judges to help do that. And so, we didn't have a lot of information about how the judge did jury selection. But
I don't think the judge knew that he was trying our case that day. I mean, I don't think there was any way we could have figured out. I mean, we knew who, because they hadn't ever assigned a judge.
Right. And so, if you know somebody that has tried a case in front of the judge that you're about to be in front of, at the very minimum, you need to know how they conduct jury selection, because you don't want to have a plan and then have to change that plan immediately after you get into the courtroom. And the reason why the plan is so important is because we ordered our questions how we normally do, to try and get as much information as we could, to try and cover all of our bases, to, ask the questions to kind of match our narrative, to make the events of the case and the timeline of the case match the timeline of the question, so that we're almost guiding them hypothetically through the story without telling them anything about it. If I had known that I was going to have 25 to 30 minutes, I would have asked very different questions at the beginning, and I would have made sure that I got my most important questions out. And I would make sure that, as Mike has just put up on the screen, that anything I want the jury to know about, that I want to go ahead and not hide from, or not, just make sure we get all of our bad facts out, so that we don't seem like we're hiding them. I would try to do that, because I don't think we got the opportunity to do that because of the time constraints.
Yeah, I mean, the way what we figure out jury selection is we sit around and we say, what are the absolute worst things about our case? And here it's the lack of impact. Here it's our client hasn't treated. Here it is that the MARTA bus driver admitted that he was at fault. And we take those, and I know that last one's a positive as well, but it has some negative ramifications too. It could take out the sting, but I think we don't want to overreact here, right? It's probably rare. It's unlikely that we're going to have this situation again to this extreme, but I do think I do think that we'll start moving up in our questions. We'll start moving up the bad things so we can make sure we 100% of the time get through them all. And when we sit around and we think of all the bad facts, what we say to the jury is, this case has a video. Anyone here watched a video of a crash? Everybody raise their hand. Who here has seen a video and thought to themselves, man, that couldn't have caused an injury? And then if the judge lets you, which usually there's no objection to what I'm about to say because the defense loves the idea of what you're saying, and they should. You say, the defense is going to tell you that this crash didn't have a severe impact, and it didn't. We agree with them. Who here thinks, and then you want to introduce, if you can, you want to introduce these bad facts so it's not the first time they're hearing about it, and that's what's going to make or break the case is your bad facts. I mean, if all you had was good facts, not only would you not be trying the case every juror, you wouldn't even care. You just be like, I don't care who the jury is. All I have is good facts. I'm great. So make sure you get them out. That's the first thing we can probably share with you.
Yeah, for sure.
In opening, I don't think I've ever objected ever during somebody's statement before then. So in our opening, I'm very formulaic. My openings go, I say what I call a win statement. Some people call a theme. I explain very briefly what that means. I tell the jury what our burden is. I tell the jury how we're going to prove it by witnesses. I tell the jury what the defense witnesses will be or whatever I need to do in that. I return to my theme, and then I close out and say what we're going to ask you for at the end. I mean, I'm like a robot in that, and there's probably better ways to do it, but that's the best way that works for me and the way I feel most comfortable. It also means that I can do an opening in 5 minutes about any case because I know what my pattern is. It obviously takes more than 5 minutes. But the defense lawyer stands up and says, I think it was one of the first things he said, Mike just told you he's going to ask you that this is $1 million case and ask you for $1 million. And we said that during the opening. We also, I don't think, got to say that in jury selection. Stokes, you remember saying that? Did we get to that part?
I don't think so.
Yeah. So I say it in opening, and the defense lawyer stands up and says, you just heard this is $1 million case. He calls our client, she's playing a game. She's faking it. I don't know if he said faking, but pretty damn close. And then he says, they're willing to settle this case for $300,000. So I think we had a mistrial in opening statement. We objected. First time I've ever objected in a statement. But I was in a weird spot because I was worried. I mean, obviously the jury had heard it. I don't want a mistrial. So I stood up and I took the liberty of saying out loud, Judge, not only is that highly improper and not allowed, that's just not true. That's absolutely not true. And I think the number he said was not true or was off or something. So, but I think I think that was a really weird way to start the case. A really weird way to start the case. The other really weird thing about starting the case is MARTA was not there. So on the pretrial order, MARTA put that they would have a representative at trial. Now, remember, this is a Monday. Monday? We start Monday?
Yes.
This is a Monday trial where we're not really expecting to go, although we're number 2 and we're prepared. I would have worn a different suit probably. I had my comfortable suit on as opposed to like my really good looking suit on. Is that just me? Does everybody have that? You know what I mean, though? You got that really comfortable suit and then you have that one that looks a little better.
You got your day 1 and your day 2. You started with your day 2 suit.
I started with day 4 and this wasn't even a 4-day trial. I looked like I was grayed out, but anyway. So we open and the only person sitting at defense counsel is the defense lawyer, or defense table is defense counsel, defense lawyer. There's nobody else. He's got nobody else. So first witness, I say, I'd like to call MARTA. You turn, you look at MARTA. Defense lawyers look around and goes, there's nobody here. There's nobody here. So that was a really strange way to start. So then I said, I'd like to call, I forget the guy's name now, the defendant The driver, I don't think he was a defendant anymore, but I'd like to call the MARTA driver. He's not there.
And we had kind of created a plan in about an hour, frankly, of okay, if they don't show up, what do we do?
Yeah.
And we
were not thinking that one.
Right. We hadn't kind of had a formula for what we were planning on doing and hoping to preserve whatever issues we needed to. And the judge simply said, call your next witness, call your next witness. And so
I'm like, can we hold somebody in contempt? Can we do something here?
But it actually, I think it worked out in our favor that we presented the testimony in the order in which we presented it. Because
before we get there though, you can talk about how I think it's also humorous to note, after we called our first witness, whoever it was, and Stokes will give you, after that witness, I then stood up and turned and looked back at MARTA and said, we'd like to call MARTA. And we repeated that pattern. And that ultimately, I think became a really easy thing that we didn't even have to really say much, that MARTA doesn't care. MARTA does not care. And
also in opening, Mike in opening always talks about how this case is important, that it's important to our client, that they've been waiting for a long time, and that we hope that it's important to the defense. And I think in this particular case, that was really, really impactful, because when you said, we hope this is important to the defense, we turned to the defense and nobody was there.
Yeah.
And so we kind of had that set up for, if they showed up, then they're showing up late. And now they realize it's important that they be there. And if they don't show up, well, then obviously they don't think it's important at all.
Yeah. What was the order that we decided to go into? Remind me. I escapes me at the moment.
I believe we played Dr. Barber first.
Yeah. Which, and this is why I think that worked. I mean, you said it too. And I think we'll do this by choice in the future. In a case where the issue is the injury and maybe the impact, and could you be injured in that way, that thing, and whatever happened. If you have a good treating doctor who's a good testifier, who makes sense, it's good, it's honest, and it's a good direct that you can play for the jury or whatever. I think starting with that is really damn good, because you start with an expert witness that says, this lady's hurt. This lady's hurt. Yep, she's hurt. And obviously we had the benefit of the defense withdrawing their expert to combat that, I think, because that would have been worse for them. But by starting with the treating doctor, it kind of got that out of the way. And then the jury didn't start with looking at that like we did in this webinar. The jury didn't start with that video and say, oh shit, nobody could be hurt from that. They started with the idea that there's a dispute about whether someone can be hurt. And here's this, from moment one of the trial, here's this witness who says, this expert orthopedic surgeon with great credentials, who testifies well, who showed imaging and so on. He says there's an injury. So I think in the future, I mean, if we have a case where we're in this kind of situation where maybe it's a low impact, not a lot of property damage or something like that, I think we really sit and have a good conversation about whether to start with that treating doctor, because it starts with, here's the most credible person we have. And then the defense is on the back heel that they have to, or back heels that they have to overcome that, as opposed to, here's this video and now let us overcome the video, or us overcome the lack of property damage, great property damage photos.
Yeah. I mean, when you have the doctor that's already testified to causation and that person's credible, then it's almost like, okay, the video now just confirms the doctor's opinions, as opposed to, you saw the video, now you need the doctor to explain to you why what happened in the video happened, or what injuries occurred.
Yeah, and I'm going to update this little list that I'm kind of building as we go here, and I'm going to call it, should you call the doctors first? Because in our world, and frankly, I think all lawyers focus too much on liability, who's at fault, the crash, the impact, the whatever, as opposed to the damages. I think that's just a fault of all of ours. Our natural intuition is who to blame. But our typical order is, we call the defendant almost in a direct examination kind of way, and say to the defendant, what happened? Who are you? What happened? And we don't cross the defendant. at least very much. And then we go to usually an independent witness, a police officer, a scene witness, whoever, that hopefully can give a unbiased, no, this is what happened. Maybe there's another one of those that unbiased witness says, no, this is what happened. And then by the time it gets to our client doesn't have to do the heavy lifting because somebody's already proven it. Our client usually comes after their doctors. So we go into the doctors after the scene witnesses or whoever. But I would consider just bumping up the doctors and switching around way more. And this is very similar to what we did the week or two before in Gwinnett County with our other case. And it worked twice. Doesn't mean it's going to work again, but I think it makes a lot of sense. All right, Stokes. I'm looking at your list. Give me your next one.
Yeah. So after we played the doctor, we played the physical therapist. And then we had our client on direct. You know, as far as preparing your client, I think that can be the most nerve-wracking part of trial prep because it's somewhat outside of your control. It's a lot of it's outside of your control as to what's going to be said. And you can control what you say in opening. You can control what you say in jury selection. You can control what you say in closing to conform to the evidence. And a lot of the doctor's depositions have been pre-recorded and they're already done. But this is the variable that's a little bit unknown. And so in this particular case, because our client hadn't had treatment for so long and her surgery was years ago, we had to overcome memory and lack of memory about what was going on. A lot had happened, obviously, in the world, 2020, 2021. And so we spent the entire week before trial meeting with her in person.
And our worth saying, our client, her family, very, very, very nice people. Very good, I think, very honest people.
Yeah.
Important to note, though, she showed up to trial in pajamas. And that wasn't that we didn't tell her, here's what you wear to court, here's what you don't. You know, she showed up to court in pajamas and a hooded sweatshirt or whatever it was. So, you know, our client wasn't somebody who, I guess we were really worried in that leading up to trial, we were really worried of overwhelming her, right? I mean, you're trying to teach her own history of her injury, but at the same time, I don't think she could retain it all.
Yeah, well, and I think the important approach, and we started doing this in depositions as well, although the depositions obviously tend to be closer in time to the actual time of treatment, is so many people, and I've been guilty of this before too, have a direct in mind and they run through it with their client a bunch of times. And I think what has to be done, especially when the trial is so far removed in time from the treatment, is you have to teach your client their story again. You can make a timeline of their treatment that's as simple as it can possibly be. You can create, you can ask them to explain it and then fill in the gaps and make a document that you send to them and have them kind of look through and study. But when you teach them answers to questions, there's no movement there. If you reteach them their story and the light that's most favorable to their case, they're going to fill in the gaps in their memory with explanations that are, you help them reach. And so I think timelines are important for that. I think maybe a short 2-page little study guide with bullets. I think we did a combination of that here that, we have met via Zoom, we've met in person, and we have the client kind of create it on their own and then give it to them so that they have something that they can look back at and review on a daily basis before trial.
I think we're somewhat unique in this, in that we don't write questions that we're going to ask. What do we do instead?
We write down what we want to elicit.
I think that's a good practice. I
think it allows for a more, that's how I was taught, because I was taught by Mike when I was in law school. So, that's always how I've done it. So I don't really know another way, but it helps to create a natural flow to your direct. A direct is a conversation. You're trying to have your client tell their story, and you want to be in the background as much as you possibly can. You just want to prompt them to tell that next part of their story. And so if you have a bunch of questions and they get nervous about whether they're giving you the right answer, then it's not going to tell that cohesive story. It's not going to come across well. If you have a bunch of things that you want them to say, you can ask your questions in a non-leading way that still leads them towards the right answer. And so that's important. And it also helps with cross-examination, because when they're on cross, no one can predict every question they're going to be asked. You have topics that you know are problems in your case that hopefully you've talked about in jury selection. Maybe you didn't get to it because you got cut off 25 to 30 minutes into it. But if they're asking, if they're topics that you know they're going to be crossed on, then talk to them about that. But you can't phrase it in the way that defense lawyer is going to phrase it. You can't do the order that they're going to do it in, because you don't know what those are. If you teach them their story though, and you tell them the points that they need to make in cross-examination, then you are basically training them on how to be cross-examined in the context of their story, as opposed to training them on how to answer questions.
Let me show. So this isn't the most exciting thing, but it may be worth taking a look at. So when we talk about preparing witnesses, and this is a cross-examination, it's a little different, but preparing witnesses and having the information we need and how we do or don't ask questions or write those questions down. I call these a bullet. I think I stole that from somebody, but this order kind of, this format is what we use for everything. So page 1, you're going to have your witness, whoever it is. This was Michael Harrelson. We assumed was the MARTA representative. It wasn't. Never saw that guy in the flesh. Didn't show up. But we have a need. You know, what do you need? Do you need to have these 5 exhibits in your hand? And as stupid as it sounds, having that need on the front page of each witness stack is really helpful, because you don't stand up and get halfway through your direct or cross and then say, oh shit, hey, where's exhibit 5? And so we try to avoid that. We're gonna have a topic. A stupid thing, all pages are page numbered. That way, when you drop your shit on the floor or you combine your stuff, you mess it all up, you know what you're looking for. As dumb as that sounds, number your pages. But I'm not going to ask him, how many people did you have out there? How many people did MARTA have out there? What I want to get from him is, you had 3 people out there. Who is the man? And I'll show exhibit 11. And I can do this. I mean, these are the statements I'm trying to get him to agree to. Easy example. It's much easier to show you this on cross-examination, because that's what the question is. On direct, though, if this was a direct, I would say, who caused the crash? Who didn't cause the crash? Did anyone say they were hurt? And instead of getting in a really bad habit of, oh, I asked that question, I asked that question, I asked that question. Instead, on a direct, I'm crossing this off when the witness says this information. I'm crossing this off only after the witness says this information, and so on and so on. So I'm not worried about asking the question. I'm worried about eliciting the substance, and I want to get the substance. Is that a good way to say it, Stokes? Does that make sense?
Yeah. No, I think that's spot on. And it's easy to lose something if you have a list of questions and you don't get the right response, because you're worried about asking those questions and you just keep going down your list. It's kind of like everyone's been in that deposition of somebody that just reads off of an outline and doesn't listen to what the actual response is. And if the response is that your client gives way to a new question that's going to be really bad for your case, and they just blaze through it, you're like, wow, really dodged the bullet there. That's obviously not what you want in your direct. You want to make sure that you don't ask questions to the detriment of getting the information that you need.
Why is my screen sharing paused? Can you see my screen?
Yep.
Oh, with my stuff I wrote?
Yeah, MARTA knew everything.
Right.
Yep.
No, that's my issue.
Okay.
You would think, 2023 May, I'd have this figured out, right? Like, I started this by saying I've done 50 of these, and then I can't share my screen. Can you see now? Are you good now? Yeah. So don't write your questions, whether it's direct or cross. Don't write your questions. Write the substance and get to the substance. And what you should have is, at least what we do, is I have a copy of what I need to get from the witness in order by topic, so on. And every topic is a new page. That way I'm not, when I get to the end of the topic, I say, okay, I'm done with that. I flip it over and I'm done. Stokes in this case, or whoever, is with me or vice versa, the other person you're trying the case with also has your same thing, and they're going through check, 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 check. At the end, you turn around, you say, did I miss anything? And they write back, they write back, they go, yes or no. And if it's a no, it's come over here. Here's what you missed. You know, I don't know if anybody's done criminal law. I haven't. I just know the easiest way to fuck up that kind of case is don't get venue. You have to prove that the criminal act or whatever happened in your jurisdiction. So if you don't say where it happened, it's like this, I don't know, it's kind of like a balk in baseball. There's a baseball reference, Stoke. There's a ball. It's just this technicality that, you know, if you don't ask the right question, you can't win your case. So to me, you know, you want to turn back to your co-counsel and say, you know, am I good? And then they run up and go, no, you didn't ask where this crime happened. You didn't make sure you do that. So make sure you have a teammate. All right, let's talk.
It's also important for exhibits too. I mean, it's kind of like a dance where one person's making arguments or asking questions or whatever, even if it's at a hearing or a trial, and the other person is looking down your checklist and you've got exhibit 3 on this line, so they can have that ready to hand to you. And, you know, that way you're not scrambling or interrupting your questioning to go get or find whatever you're looking for. The person has it there to hand it to you.
Yeah, and that shows two things. One, it shows that you are extremely prepared, which I think is vital to the jury. And two, because of that, it's going to give you credibility that you're an expert in the courtroom and you know what's going on. I run around saying, and we're going to talk about damages now. I run around telling everyone that the way you get large verdicts is by being trusted and credible and believed by the jury. And I always feel weird saying that, because then it's like, well, how do I make the jury just believe me? And the tips that I have and I've given in the past, which still hold true, seems so stupid. But the way I'm going to explain today is I think that credibility with a jury is about the little things. I don't think it's about the big things. Granted, you can't go up there and tell them the sky is red. That's a big thing that you'd have wrong. But I really do think it's all about the little things. It's from the moment the jury walks in, and this sounds so stupid, but I believe this with my whole heart. When the jury walks in, you stand and you look at them, and when they look at you, you look back and you look confident. It is that your counsel table doesn't look a fucking mess. It's that you are professional with the court staff and the court reporter. It's that if you can, you name drop. You know, oh, Deputy Smith over here, if you have any questions, ask Deputy Smith. He'll make sure we're all safe and get you where you need to go. As you will see during the trial, I'm going to try my best to talk as slowly as I can. And that's because Crystal here is our court reporter, and she's writing down everything I say, even right now. So you're telling the jury these basic things that everybody knows, but you're stealing that expertise because you're the one saying it. With all respect to judges, once the trial starts, it's not their courtroom, it's mine. And I want the jury to I've never been in this courtroom before. I've probably never, I've never been in whatever county before. But when I walk in there and the jury's inside the room, welcome to my living room, and I'm not going to put my feet up. I guess I'm going to be in my parents' living room, right? I'm comfortable in there, but I'm not going to mess up the place. And it goes through jury selection where you are, as the first one standing up, you tell the jury things that are going to happen, that everybody in the world knows are going to happen, that they're not, which is, I'm going to ask way more questions than the defense lawyer is, because they've got the easy job here today. They make me do all the hard lifting. So I hope you're not upset with me when I get done with this, that I'm going to have spent a significantly longer period of time. Or an opening, you tell them the defense is going to talk to you all about the burden. They're going to say I have to prove beyond a preponderance of the evidence, but look, that's just me sitting at my kitchen table and we're talking shit about our friends. And do you believe that Steve cheated on Susie, or do you think Susie cheated on Steve? Which one do you think's more likely? That's all it is. But there's moments through, and maybe next trial we should try to write these moments, but there are moments throughout the entire trial where you gain little pieces of credibility, right?
Yeah, and I think there's something that happened in this trial, actually, that I just remembered, and I don't know if you remember this, that happened before trial happened.
I blacked this shit out because this was this was a shit show of a trial.
Yeah, we were waiting for a really long time because they're going through all those gang
The YSL trial. Yeah.
gang trials. Yeah. So we were walking in and we had all these boxes, and there was this woman that we were just like, we weren't engaging her because, you know, we didn't know whether she was going to be in our jury pool or anything, but we were nice to her. She was kind of asking us what we were here for, and we were like, oh, we have a trial, tried not to say too much. But we were nice to her. And then we kind of like let her go through and all this stuff. And then we made some, you know, small talk joke about waiting in line or something like that. And then we come into jury selection and she's in our jury pool. And she answered.
I'm like this looking at her. I'm like, what's up? What's up?
Exactly. And so she answered every question we asked, because we'd already had like this, even if it was just like small talk and it was about the weather or traffic, which, as Mike knows, I roll my eyes every time anybody tries to talk to me in the elevator about weather or traffic. But even if it's that, when you're walking into the courtroom, if you seem familiar with the courthouse, if you seem familiar with the security process, if you feel comfortable enough to just make small talk with people as you go in, those people may be on your jury. And they may like you more or be more willing to listen to you because they've had that icebreaker encounter.
Yeah, you go through security. This happened in Gwinnett 2 weeks earlier. Going through security, there's a juror like 3 people behind me, right? And we're not talking, obviously, but it's day 2 or 3 of the trial. And I get up to the security guard. I've never seen, you go through their security checkpoint or whatever. I've never met these people before, ever. And I'm like, hey, what's going on? Good to see you again. How's it going? And they're going to be nice and kind back to you because they, I'm another white dude with brown hair. I look like everybody else that's walked through there this morning. They just think it's, Tim got a haircut. So I as much as it sounds like bullshit, is 100% true to fake it until you make it. So, and here's what I'm building up for. Here's the ultimate buildup. I don't think that jurors know why they award the money that they award. I think they can come up with reasons, and they can tell you, we did this or we did this. Potentially in this case, the jurors did a quotient virgin. Wow, that was nice. Quotient verdict. Maybe that's what they said they did, which could be highly improper. Potentially.
Maybe they did. Maybe they did.
We don't know, but that was discussed at least maybe after the trial. But here's the thing. The defense asked for $0. We asked for 1.1 to 1.3 or 4, 1.6, 1.1 to 1.6, something like that. And I don't think the jurors ever really hesitated. They just said, yeah, it's what Mike says it is. And I know that sounds, I hope that doesn't sound arrogant or, but I think that's what truly happens. The jury just goes, I believe that guy, or I believe that girl, or I believe whatever, or I don't believe either of these fucking guys.
Yeah. Well, and so much, and you may be getting to this, but one of the things that I've seen Mike do several times in several trials now in closing is, this is the most that you should award. Don't award more than this. This case isn't worth more than this number, but also this case isn't worth less than this number. Don't return a verdict less than this. And so when you put a ceiling on what you're asking for, instead of, oh, well, you can decide that, we're asking for 10 times the medical bills. You can decide that it's worth 30 times the medical bills, or however many times you want. That's an endless upward, there's no ceiling there. If you put a ceiling on it and you're willing to do that, and you're willing to say, don't award more money than this, then they have that number in their mind, and they're more likely to accept your credibility on your lower number. Yeah.
And the reason that idea came to me was because in a trial, a defense lawyer said, hey, this is a big negotiation. Look, they're going to ask for a high number. Our number is going to be low, and everybody expects you to find some number in the middle. And I'm like, first of all, you're telling the jury that you're giving them a bullshit low number because you're not good enough to get that number. Like, that's what you're telling them. I can't persuade you to give this number, so I'm going to think you're going to go in the middle. And I stood up and said, no. The time for negotiation is well over. And I'm not going now. Hopefully I've built up 3, 4, whatever days of credibility. I say, I'm asking you for this number. I'm not asking you for above this number, because that would be wrong. I would never ask you for a dollar that if it's not worth $1. And I'm also not going to ask you for 50 cents when it's where you also, I guess the line I say or something I say is, if this was a $2 million case, I say don't award more than $2.5 million. Just don't do it. It's not a $2.5 million case. Maybe your range should be 2.5 to 1.5. I can understand that as being reasonable, but the real number is 2 million. You should award 2 million. Whatever you do, don't award less than 1.5 because that would be unreasonable. So you want to give them some wiggle room. And I guess and I'm going to show you the job ad that we used here because that gained some attention, I guess. So here's what I'll tell you. Give a cap, like cap yourself. Give a cap and cap yourself. Also give a floor and make sure that in that range, you tell the jurors that that is a reasonable range. And then you have to give them something in the middle of the range that can't be argued. Can't be argued. What the hell can't be argued? Huh? Well, and I'm going to plug myself here. I have a video on YouTube. It's from GTLA maybe 2 years ago, I think, where I did a presentation on the ask. And the whole idea of that presentation was that we equate time with money and money with time. And you're a plaintiff's lawyer on this, and you're like, fuck that. That's why I do this. I don't want to bill hours. I don't want to, look, the harder you work and the more work you do, generally speaking, the better results you're going to have. But put that aside, I'd actually like to know what percentage of the workforce works on an hourly basis. Like that, I'd love to know that. But anyway, I think it's safe to say that we equate and jurors equate time with money and money with time. And they're missing work generally, or missing whatever they're supposed to be doing in their life to be there. Stokes, what is a number that can't be argued with that the value of someone's services are worth?
How much they're paid?
Yeah, what's the number though? There's a number.
Minimum wage.
There you go.
At a minimum.
Yeah. How can
you can argue that you should be paid less than minimum wage for anything?
Yeah, well, I mean, there's some states allowing child labor now, but we're not going to go down that road. But yeah, in this case, what we did is share this bad boy. We were trying really hard to think of how we're going to do this because we didn't have a extremely compelling case of future damages. So this is Indeed. And look, a lot of shit to the Fulton County Courthouse administration and stuff like that. They do trials through Zoom, positives and negatives. Really good positive though is you can go on the internet in the middle of the courtroom and just pull things up. So during my closing, I'm live on the internet and I pull up this job post. And this job post is for a car crash victim. Funny enough, we were hiring. I think nobody applied to this. Maybe we got one. But what's the job type? Well, it's full-time, but it's also overtime, overnight shift, whatever options that they give you. Indeed hasn't caught up with the fact that, there's going to be no labor laws by the time we get done with this. So, but back then I had to sign, or they sent me a special email. And I told the jury this, I had to click a special email to say that I wasn't violating labor laws because they're like, you can't have somebody work that much. And then here's the job.
You said that to the jury.
Yeah, we did. I definitely did. Yeah. Said whatever I wanted in that trial. Yeah. So here was the job description. I'll read some of them or give you categories, I guess. You got to be healthy. You're going to get hit by a MARTA bus. Don't worry. We can show you the video. You go to the orthopedic surgeon. Here's all your pain. Our client had surgery. She had 4 scars. She was out of work for 6 months. Went to 31 physical therapy sessions. We were wrong on the medical bills. It was 141.9. Felt like a 130 something to me. Felt like a 130 something. You need a surgery. You got to hire lawyers like us. You're going to be blamed by MARTA for hitting the bus. This is the line that was said in opening. I added this to the job post after the first day. You are playing a game and your injuries are exaggerated. That's what they said about my client during opening, which is such a fatal, stupid thing to do, a fatal flaw, because at that moment, you do not have credibility with the jury. They don't know if Our Lady is Mother Teresa or if she is insert tellable person's name. So when you start an opening and criticize someone who could be the worst person in the world, but the jury doesn't know that yet, you're not buying credibility. They think you're a jerk. And they think that you are partisan and that you are, there. I try to call as many people good, honest people as we can on both sides. because you don't want to be the guy or the person that is criticizing unfairly someone else. So by the time you get maybe to closing, the jury's at a 6, angry with somebody. You then only want to be a 5. You need to be lower than the jury's credibility. But you have to have a deposition, and our client did a good job of explaining what that is. Must have waited for years to go to court. And I thought this was the best thing that we added to the job thing. You have to bring your kids to court to speak for you. Think about that. You're a grown-up, a grown-ass adult, and you got to call her daughter was 18, son was like 20.
Yeah, they were in college.
Yeah, and you've got to call your kids and say, I need you to come to court because people don't believe that your mother's telling the truth. And I thought that was a really powerful thing. The pay, you can't leave it blank on Indeed, so we just use this. Here's your schedule again. I guess we did have one candidate. Nice.
At the time, we didn't.
Yeah, no, it's high. We're only hiring one person. Okay. So then, you highlight this part and we said, look, this is the job of this case. This is what we are asking you to value. And you got to figure out what is a fair value. And what did we use? $5 an hour. And we said, I wish I don't have the PowerPoint on me, forgive me, but I'll try and find it and send it out to you guys on my email. But we said $5 an hour, we didn't think was fair. I think we did $10 an hour at the high, and we said, this is pretty much what we think the high would be. And we did it for the rest of her life, because we called this a permanent lifelong injury that is going to have negative effects for the rest of her life. And I didn't parse the fact that, she may get better a little bit, she may not. I just told the jury this is a lifelong injury and you're compensating somebody from what they've lost and what they're going to lose in the future. So then you get to minimum wage and you go, look, you can't argue with minimum wage. We've decided as a society that things should be valued at minimum wage. And when you do that math, I think it was like 1.1 and change, or 1.2, if I remember right. And after the trial, jury awards that money, and they have 9 different reasons for why they came up with that money, that number. And I think the answer, though, is because when I said the number, they just believed it, and then they justified it in their head in another way. That's what I honestly believe. And that's not a me thing. I think, when, I don't know, some other lawyer who, one of the 5-10 guys, I'd run down to the courthouse to watch a trial if they had one today and want to see their closing. I think the same thing happens, is that the jury just says, yeah, dude says it's $1 million. Must be $1 million. And then they go, when I think about it, yeah, you get to $1 million because it's this, this, and this, but there's never really a dispute in their mind about what it's worth. And I think that comes from all the little moments of credibility that you build throughout the entire trial. And I think that's probably the thing we do best at trial across the board. So we don't take extreme positions. We tell the jury we told the jury, this is what our client thinks happened. We believe that's what she thinks happened. But let me tell you what I think happened and what the evidence shows. And you can diffuse that as opposed to touting or toting. Is that the word? What's the word? Toting the company line? Touting the company line? Whoever that word is. Following, what you think you're supposed to do because you represent someone. Last little story, very quick story I'll tell you is I had a client once who I was really worried going to trial that he wouldn't even let me make a reasonable ask. I was really worried about that. And we compromised. I told him I would tell the jury what he thinks his case is worth, and as long as he let me say what the case was actually worth to the jury. And so I said, my client thinks the case is worth hundreds of millions of dollars. Shit, who's to tell him that he's wrong? He's the one who went through it. But we're not going to ask you to award that amount of money because that's not a reasonable amount of money to award. And just by being upfront and real and honest, and treating people well, pretending like you're the expert, like you've been there before a million times, I think that's going to do really well for your ask. It's going to make it easier for you, especially if the defense gives you a layup and, criticizes your client in the opening statement, pulls money essentially off the table, and then doesn't even show up at court. But interesting, and I think this is important. The jury, I don't think there's been other verdicts we've gotten that were the result of jurors being mad, good at making people mad.
Yeah, these people weren't really all
No,
that mad at Marta.
No, we were like, did you care that MARTA didn't show up? And they're like, nah.
Huh.
I was like, what the fuck?
They're like, I was mad that they didn't show up.
I was very mad. I was very mad. So if you all have any questions, let me show our list again to you and I'll email it out so that you have it. But these are 5 things I truly believe that you can do that will improve your cases. Make sure that you know what you're allowed to do in jury selection. Everybody tells you that. Most importantly, make sure you get your bad facts out. Sacrifice things you think you want to know for, I'm going to tell the jury the bad things about my case. Make sure that you have thought all about your witness order, even if witnesses don't show up, and consider this idea that maybe you're doing that we hadn't done until this year of calling doctors first as opposed to the damages. I think Stokes said this the best: when you prepare your client, teach them their story. Teach them their story. Don't teach them how to do a direct examination or how they should answer on cross. Teach them their story. You can do that by creating exhibits for your client, which is what we did. We didn't show. We created things for her preparation that we'd never used at trial.
Yeah, it's a communication created by me to her. It's privilege. And she can look at it as much as she wants unless she's on the witness stand.
Yeah, and hopefully by the time you do that, you figure out, is your client a visual learner? They want to read? Do they want to see you do whatever it is? And then cater to that. Ask them if you don't know. When you're writing questions, make sure you write down and get the substance out. Substance, substance, substance. If you're thinking about your next question, you are going to miss something. You are going to miss something. You have to be a truly active listener. And the best way to do that is only focus on what's being said to you. And don't worry about what you're going to say next. If you then have to look at a piece of paper and say, oh, okay, that's the next thing I'm supposed to get out, that's totally fine. I think I can, maybe my ADHD allows me to do 9 things at once, undiagnosed, obviously, because who goes to the doctor nowadays, right? Copay is so high. But I think I can have a lot in my brain, but I know I'm still, if I get sidetracked on something, or if a witness says something surprising that I'm not expecting, that's going to cause me to miss my next point if I'm just writing down the questions. And then the ask, give a cap, give a floor, give something, if you can, that can't be argued with, that justifies your range, That's what I got. So there we go, share screen. This was an interesting case on a whole lot of levels. These were probably the 5 takeaways that we walked away with. Anything you want to add, Stokes?
No, I mean, I will say this, and I know we harped on it a little bit at the beginning. Trial calendars are nuts. And so if you get emails that say, well, we want you to be here just in case, you need to treat that as if you're going to go. Now, 2 weeks ago, we had another trial scheduled in Gwinnett County, and we were the second case up, and they said, we need you to be here just in case. And I had prepared that case to go to trial that day. We had our witnesses ready. We had our client ready. We prepared for it the same way that we did with Duncan. But if you're on a trial calendar and you're banking on someone else going first, you're going to end up like MARTA did in this case.
I got a question for you. I'll probably cut this part of the video when we're done or something. I probably won't, let's be honest. For all of you, these videos that I do, which I enjoy doing, and it's becoming a routine that these are put in front of judges. So every video I do at this point now is highly scrutinized. And I would imagine the majority of my views are now lawyers, defense lawyers looking to, like literally everything that's filed. It's like, Mike said this. Yeah, I did.
A quote in a YouTube video with a link in a footnote.
Yeah, taken out of context, but still totally okay with what I said. What I was going to say, though, ask you, do you think if we were specially set, MARTA's defense would have been different?
Yes. Oh, 100%.
I don't know
I think they would have had different people there. I mean, one thing we didn't really touch on was that they also made the bus driver the MARTA representative.
it was so stupid. Like that was so stupid. What lesson do you learn from that? Right. I'm trying not to just shit on people, and I'm trying to give people valuable lessons to take away. You know, if you're doing defense work and watching this, don't make your driver the corporate representative, because then when he takes the stand and he's cross-examined and I say to him, hey man, you know, you're the MARTA representative. He goes, no. And I was like, but you heard when you took the stand, they said, this is the MARTA representative. And he goes, yeah. And I was like, you comfortable with that? And he goes, no. And I go, I wouldn't be either. Well, I'm sorry you're in this situation, but I got to ask you the questions.
Yeah.
And I think that respect that I gave him, though, and understanding the perilous situation he was in and the unfair situation that his own lawyers put him in, again, I think that gains credibility. And it wasn't in a bullshit way. I said to him, I said, are you comfortable with this? And he goes, no. And I said, I wouldn't be either. I'm really sorry. And I truly was. I'm sorry that you're in this situation. I got to ask you my questions, though. And I venture to say, I bet all your answers are going to be, you don't know because you're not MARTA, but hey man, I got to ask you my questions. And him and I, while the jury's out, are sitting there shooting the shit, talking, because he likes me as a human, because I treated him fairly, while MARTA and their lawyer, I guess, treated him like a throwaway, disposable employee that just had to be there because nobody from MARTA actually showed up.
Yeah. I mean, going back to when you were talking about specially said, and would it have changed anything? I really don't think it would have changed the result. I think it would have changed who MARTA had there, but their strategy was going to be the same, whether they had a representative there that was different from the driver. And because of the feedback that we got from the jurors afterwards, with them not being mad at MARTA, I don't think that MARTA's conduct really factored into their award. I think if they had brought a representative that had said a bunch of stupid shit, then maybe it would have. But, you know, well, at the end of the day, I think the case value was what it was because of the way that we presented our case against the way that they presented their arguments.
Well, MARTA's lawyer would disagree with you, given his comments in the Daily Report. I'll end with this, and Stokes, I'll kick you off. You can get out of here. Let me see how I can kick you off here. I'll end with just my thoughts on some things that have been going on. See ya. Thanks for joining. Adios.
Thanks.
See you, Stokes. Hopefully he goes away. There we go. After this case, MARTA's lawyer made some comments in the Daily Report in an article about nuclear verdicts. I wrote back in the Daily Report or commented back, and it got published. But it was my thought is that my thought is that nuclear verdicts are the result of bad lawyering. 100%. It's bad lawyering caused by being a shill for your client, or I guess taking unreasonable positions because you think that's what your client wants. One of the things I learned from Scott Farrow, who is now a plaintiff's lawyer, but Scott Farrow was kind of my boss over at Troutman Sanders and now Troutman Pepper. And we had a case where we didn't admit something we should have. And we kind of weren't allowed to by our client. And I think Scott said, we'll never do that again. We'll never let that happen again. And we were very aggressive in the sense that we would admit things that were true, but we still could have denied. And the result of admitting things is, again, you're gaining credibility. I don't mean to keep coming back to it. But on the flip side, if you're not going to admit those things and it's obvious, you're going to make people really mad. Or you're just going to turn them off and make the other side look really good. So the Daily Report's been on this run of nuclear verdict, all these nuclear verdicts. And then you see, a settlement come out that's $50 million. Or you see a settlement that comes out that's, $20 million, whatever the number is, these really large settlements. You never hear the phrase nuclear settlements. And the reason is because deep down inside, everybody knows what a case is really worth and what a human life is worth or what an injury is worth. But if it's a settlement, it's totally okay and agreed to by both sides. But if it's a trial, it's suddenly a nuclear verdict. What I mean by that is, if you were to settle a case for $20 million, no one bats an eye. Everyone says, oh yeah, the injuries must have supported that because both sides agreed. But if you take that $20 million case and you settle it, or you try it and you get $15 million, you're going to get told that's a nuclear verdict, and people are going to scream up and down that this was unfair, even though the settlement should have been $20 million. I say that because our job is a bullshit game in that regard. And the noise out there about what is a verdict and what's fair and what's not ultimately does not matter. What matters at trial is what those 12 people think. And I think it's really fucked up that so many lawyers are so quick to blame jurors and criticize 12 random ass people that don't know shit about the case before they walk in, to criticize them for either being prejudiced, swayed by some sort of feeling that caused them to award this much or this little. So I guess my little quick takeaway from just the world around us is that it's really fucking hard to convince 12 people to do anything. We have about 12 people in office. I couldn't convince 12 people where we should go to lunch. And this is my job, is convincing people of stuff. I can't convince anybody of anything. What I can do is I can give you the information that allows you to make a really good decision. And if the information I give you is enough to make you feel confident and make you feel good and give you the peace of mind to sit back and make a decision, even if you think that there's another side of the story that isn't particularly persuasive, even if you know that's out there, you're willing to disregard that. And you can convince 12 people that you have done an incredible thing. So I guess I would ask everybody as you go through this world to make sure that you speak highly of jurors, you speak highly of our court systems, and you speak highly of other lawyers, because everybody wants to get out of jury duty. But these are the people that we rely upon, that our clients rely upon to deliver the good news. Think about how bad of a situation you must be in if you're willing to let 12 random strangers who you've never met, who couldn't figure out a way to get out of jury duty, to let them decide an important thing in your life. You wouldn't let them decide who to marry. You wouldn't let them decide what car you should buy. You wouldn't let them decide where you go to school, where you live, any of this important stuff, where you should work. But we're trusting 12 random ass people to decide these really important things in our clients' lives. And then lawyers have the nerve to criticize those jurors. I think on the whole, jurors get it right and lawyers get it wrong. So I hope that's quoted one day in one of these clips that gets grabbed and put in a brief or a motion. So that's my 2 cents. I hope you all have a great rest of the week. I see a question. I'm going to hang here and answer some questions. Have you had a case against MARTA or other entity that have a policy where they have video cameras and then they claim not to have video, the cameras weren't working? Yes. You used to could lay the groundwork in discovery and say, hey, you guys have video, this didn't capture this, blah, blah, blah. And then at trial, you'd be able to kind of spring it on a witness and say, hey, you say you have video, but you don't have it, and basically argue spoliation to the jury. Really important. Now, I think it's a Joe Freed case and a Mike Goldberg case. I'll include it in my email that I send out, but now you have to go, and it's a judge question. Maybe it's always been, but it wasn't clear. It's a spoliation as a judge question. So you need to prove it up in a motion, and you need to have the judge handle it as opposed to you arguing it to the jury. But I'll send out that case. That's really important. I think that will give you a framework for what you're supposed to do. But yeah, I mean, what I see more, frankly, though, with videos, and MARTA was good at this. They saved everything. But, Stokes and I have this wrongful death fall case. And the defendant in that case, Kroger, only saved a portion of the video. So, their defense is, well, we don't know how long that substance was on the floor and blah, blah, blah. Well, yeah, but you only saved X number of minutes before the fall and X number of minutes after. I see that a lot, and we haven't really figured out what exactly to do about that yet. But that's what I see a whole lot is kind of partially saving video. Let's see. Thank you. I did that. I'm assuming what we're talking about right now. The judge hasn't ruled on it, and it was heard in February. I assume we're talking about a motion like this. But yeah, I don't love the idea that you don't get to argue spoliation to the jury unless you have, you know, the inference or whatever it is from the judge. I don't love that being a jury question, but that's the law and that's what we got to deal with. All right, folks. Anybody have anything else? I appreciate all of you that stayed. I mentioned before I even started, there was a name that I didn't know. If you are someone I don't know, call me, text me, send me an email. Let's go and get together. You see me and I don't get to see you. I'd like to see you in the flesh. Also, congratulations to Kimberly Mowbray's son, who's an all-star. I saw that on Facebook. I like that shit. That was he just graduated or finished a grade, but won like more awards. And I went home and I was like looking at my kids being like, what are you going to do with your life? Why can't you win a science award? Somebody said, I have a similar case with MARTA where there was a video and a very small impact, but the client is unruly. Do you think it changes your outcome if you don't have a nice client? Yeah, I think that jurors give money to people they feel sorry for and that they like. So if your client's not likable, that's a big red flag to me. We've lost 2 trials ever at our firm. One was a fire case where I came in, I don't know, 6 years after the fire and there was no experts. And I proved to the jury that the fire didn't happen the way the defense said, but I didn't prove how it happened otherwise. So we lost that one, which was a tough one to swallow, but knew what we were getting into. The other case that we lost was kind of a he said, she said, who came into whose lane. And the person that's going to win that is always the person who the jury likes. Look, I'm not the most likable person in trial. I don't think jurors love me. I don't think that they're like, oh man, he must be the nicest guy in the world. I don't think that for a second. And I don't think that likability means that they think you are nice or they think you're friendly. You should be. And I think I am, but I don't come across as the nicest dude in the world. And maybe I'm not. But I think I come across as someone who doesn't really put up with bullshit. I hope. I mean, I don't know, maybe you guys can tell me if I'm wrong, but that's how I think I come across, and I own that and I understand that. And I play to that. You know, if something doesn't smell right, I say this is crap. My trial word is nonsense. That's my trial word for bullshit. So I think you have to make sure your client's authentic to themselves and doesn't turn people off. They don't have to be charismatic. They don't have to run the world or rule the world. They don't have to, be a performer. But if you have a bad client, that is a really big negative of trial. It also means that your client can't do the heavy lifting. So I think it's more important at that stage or in that situation to put your client in the back of your witness order, put them in the way back. So that way they've already heard from maybe a police officer. They've already heard from the doctors. They've already heard from friends and family. They've already heard from everybody they can hear from. And then your client, it's like, oh yeah, here's my client. And your client isn't the one who has to explain why they are or aren't at fault, why they were hurt, how they were hurt, what happened. Don't make your client do all that. Get your client on the stand and get them off the stand. So hopefully the case is already essentially won by the time your client ever steps up. All right. Well, I appreciate everybody for, again, and I mean this seriously, for anybody I don't know, please respond back to the email I'll send out tomorrow with a link and with this list of stuff that I'm going to save right now so I don't delete it. And I appreciate y'all joining me. If there's anything I can do for you, please let me know. Again, truthfully, first time in a very long time, my firm is actively looking for cases. We're excited about that. We want to find some good cases. We want to find some new people to work with. That's always fun for us. Majority of our cases overwhelming majority come from other lawyers. We appreciate lawyers who trust us to handle their cases. And our best selling point is that we make the lawyers that refer us cases, we make them look good. The lawyers in this case didn't just get a check. They have a client who is past us, but they have a client who will scream from the mountains how great they were too, because we made them look really good. And that's what we think our job is when taking on a referral. So anyway, have a great day, everybody. Appreciate y'all. Be safe this summer, but I'll keep doing these webinars. If you have a topic idea, let me know that too. Those always help. All right. Adios.